Record in the matter 25 CF 160, State of Wisconsin versus Robert Teskey. The state appears through Assistant District Attorney Jose Vila in person. Mr. Teskey appears in person with counsel Joel Feliski. We're set today in this matter for the final pretrial. The court has received and reviewed the motion for admitting other evidence by the defense, which would include, I think it's all complaints as they relate to Jonathan Oyat and other individuals. As a defense in the case, the court has received and reviewed the state's response to the defendant's motion for other acts, admittance of other acts. The state did object to the filing and asked the court to summarily deny the matter. However, if the court is not inclined to do so, the state wanted additional time to be able to provide a response to the other acts motion. Am I missing anything, Mr. Feliski? Who's appearing in person with Mr. Teskey?
I believe that covers the matter as it currently stands, Your Honor.
All right, and Mr. Vila?
Two things I just want to note. So regarding the other acts issue, I state I did not write this, but I can certainly do that. I also believe the matter as itself is irrelevant. Defense's argument is that they want to do the third party. There's a third party that committed the crime. That's a third party perpetrator motion that wasn't filed. So I think the other acts motion is irrelevant as it stands. And then I just need to address one motion and eliminate that defense filed.
All right, and so I just have a question. You didn't write it. I thought that it says your name.
No, I did not write that specific argument in my response.
Oh, okay. Because I'm like, I swear it said.
I should have clarified. My apologies.
Okay. All right. And so the argument of it should be the third party.
It should have been a third party motion.
Okay. It really should have been a third party motion. I get where I understood where you were going with the other acts, but it's really a third party motion that should be filed. So with that understanding, and if Mr. Feliski does understand that now and just didn't, maybe he was thinking differently, strategically different when he filed the motion, is the state objecting to if Mr. Feliski is asking to be amended to a third party?
I would object, Your Honor, that the wrong motion was filed and therefore the wrong standard and analysis was provided to the court. And per the court scheduling order, today was the last day for all substantive motions, such as third party motions, to be filed and heard prior to today's date.
Before I get to Mr. Feliski, what is the state's issue with the motion in limine?
I want to pull up the specific bullet point. One moment, Your Honor. It's towards the end of it. I want to say it's 14.
Any recorded interviews or body camera?
Yes, that's correct. Defense is offering this motion eliminate without providing any statutory authority to support it. State's position is obviously there are no Mirandize or admissibility issues. All of it should come in.
All right. Okay, Mr. Feliski.
Thank you, Your Honor. Would the court prefer me to address the motion in limine or the other acts first?
Whatever you prefer.
In regards to the state's position regarding the motion in limine, item number 14, I'm not sure what they're referring to. I am citing authority under 906.11.1 in regards to the prohibition on that material. But I think that's a separate side issue. In regards to what I think is the larger issue at play here, Your Honor, the other acts motion, I would admit that that was a strategic decision on my part to file it as in other acts. I think my argument by and large will remain more or less the same, filed as a third party motion as the court was referring to. In regards to the state's position that this was untimely filed, while certainly would have been advantageous to have filed this in advance, Your Honor, this was filed at least a week prior to the final pretrial conference. So it is, in my opinion, timely. Moreover, I think looking at the actual evidentiary issues that are at play here, the defense is asking for admission of evidence that I don't believe is very voluminous nor especially complex. It's essentially the admission of prior convictions for a third-party witness that was involved in this matter that wasn't even charged by the state. So I would ask if the court would allow to have me amend the motion to a third-party motion and file for rescheduling to be heard on that. Thank you.
When I read your motion, Mr. Polisky, I mean, it wasn't voluminous. I have to pull it up. I didn't bring the printed one in. There you go. My thought and what I was going to do here today, regardless, I wasn't going to bring it up and state that I believed it was a third party motion versus and other acts. I'm not going to have you tell me strategically why you chose what you did unless you want to. But in reviewing my scheduling order, it does also state, you know, that with regards to the like an other acts motion, that has 2 weeks before a jury trial. So I'm guessing that's strategically why you chose to file an other acts motion instead of a third party motion. But my thought was we are still out to trial. We have a month before trial. We do have time to allow the matter to be heard. But specifically then as it relates to Mr. Vila's objection to your paragraph 14 in your motion in limine, I do understand that you have the Wisconsin statute there. And I'm going to guess if I'm interpreting your motion correctly, you understand that they have the ability to play recorded interviews in body camera, but just not any admissible portions, which would include if there was no Miranda or any other violations occurred.
I see, Your Honor. No, I thank you for clarifying that.
But otherwise, you're not objecting to the interviews or body camera, just to any admissible parts, correct?
That's correct.
And so quite honestly, unless there is anything that you both wouldn't stipulate and agree to is inadmissible, we wouldn't need a hearing on that portion of your motion. Only if there was a segment of, let's say, minute 1 through 3, where you say that there's definitely a violation there. This would prejudice my client if the jury were to hear it. That's the only way that it would necessitate a hearing, because quite honestly, I don't know if you want me to hear things that are not inadmissible.
Understood, Your Honor.
But that's, again, it's happened multiple times for trials in which the court did have to make a determination on whether or not that portion can be played. But so with regards to paragraph 14, I believe I understand where Mr. Felisky is coming from with understanding, or do you have the same understanding?
I have the same understanding now, but I do just want to put it on the record. I don't think there's any inadmissible issues with any of the body cams. So if he has a different understanding, we can certainly potentially reach a stipulation, but I have not been told otherwise.
And I'm gonna say, and that is on your shoulders, Mr. Felisky, to say if you do have any parts that you are objecting to, and to work with and speak with Mr. Felisky regarding that. And if we need a hearing, we'll get a hearing. But sometimes we don't even have the hearing until the morning of the trial. But then the attorneys already have it stipulated and already set that, okay, it may be questionable minute 1 through 3. And so you just know, and if the court rules one way or the other, then we know if we can play it or we can't play it. But with regards to your motion and third party versus the other acts, I don't think that if the court were to allow the matter to at least be heard and responded to by the state, that wouldn't be too onerous for the state. And in fact, that would alleviate any potential arguments of prejudice against the defendant and or quite honestly, any ineffective assistant argument that could come down the road, whether or not it is in fact a third party or it's in other acts or whatnot. And I don't like to have those open-ended potential appeals issues. So I'm okay with giving a date and time for a hearing. Again, we have a couple of weeks before the jury trial, but it's going to have to be kind of a quicker turnaround. Let me just try and find something. My availability is next Wednesday morning. I could do 10 a.m. And I know it's a Mr. Schmidt week, and I know it's kind of quick.
I unfortunately can't do next Wednesday, Your Honor. I have personal issues.
Obligations.
Yeah.
What about Tuesday at 11:15?
Tuesday the 14th?
Yes. Is that too quick?
That is too quick, Your Honor. What does the court have any availability on the 16th? I could make that work.
No, I have a 2-day Supreme Court committee.
Understood.
Thursday and Friday, so I can't do the 16th or the 17th. And your week, oh my gosh, your week is completely booked. How long do you think we will need?
In the alternative, I'm willing to just submit a written response and let the court make its decision that way if Mr. Filiski is okay with that.
I don't object.
Would you think that you would need any further argument? We wouldn't need any witnesses, correct?
Perhaps a brief period for a rebuttal, but I think if the state is all right with just submitting a written response, I don't object to that.
I'm perfect.
That's
Yeah.
great.
Yep.
All right, so when do you think, Mr. Vila, you can have your
I can get it done by next Friday, the 17th, Your Honor.
Friday the 17th? And I'm gonna tell you a brief rebuttal. I'm gonna actually say 16th.
The 16th?
Yeah. I'm not gonna be here, but Mr. Filiski will be able to read your response and then he can have a short reply. And I'm only saying that because I'm gonna need a chance to read this and to make a decision. And I may not, I have a lot that I may not be around for the week of July 27th through the 31st, and then boom, the next week is our trial. So for the 16th, and can you get yours done by the end of the day of the 20th, or is that too soon if you need a reply?
I'm looking to my calendar. No, I think that would be appropriate.
Or by noon on the 21st?
Noon on the 21st will work.
All right. Oh, darn it. Well, I'm going to be in Polk County all day for out of county matter, but I do have access to my things and I will get it when it's filed. I can print it there. I can review it there. I can determine, get an idea of what I'm going to do and possibly get an order done. Work?
That works for the state, Your Honor.
Yes, Your Honor.
Okay. All right. Anything further we have to address today?
One last thing on part of the state. While I am fully confident Mr. Felisky has already relayed this information to his client, I would just request a lugwood right now so he knows what the offer is.
I was going to actually, well, I guess because we're not going to have a hearing. If we're not going to have another hearing, then yes, I do need to do that. So thank you. Mr. Felisky, I just want to make sure though also that you are, if you are intending to refile as a third party, then do it. If not, and you want to stand strong on another acts, then you can do that. And for strategic reasons, then you're going to have to talk to Mr. Teskey so he can understand that.
Of course.
But if you are going to amend and it wouldn't take much modification from what I reviewed of your brief, just a couple tweaking and add this law, that thing.
Certainly, Your Honor.
But if you're going to do that, do you think you can get it done by tomorrow?
Yes, I think by end of day tomorrow, I should be able to get that done.
Is that enough time for you then to be able to do your response if he is going to modify?
I'm sorry, just to make sure I got this clear. The deadline for Mr. Felisky, if he wants to amend and file something else, is tomorrow.
Right.
Yes, the 16th end of the day, I should be able to make that work, Your Honor.
Okay, sounds good. So then we have everything covered. All right. Now I need to determine what the offer was. I don't know and I don't want to guess.
Yep, nope, fair enough. The offer is for a deferred judgment of conviction, 12 months, AOD and follow through, resulting in amphetamines for cost only.
Okay. And so, Mr. Teskey, I have to go over this with you, all right? Because I have to know on the record if you wish to consider the offer, or if on the record you're saying I am not even accepting the offer. Because today's the last day. You will not get an opportunity later to go, hey, Judge, I really want to change my mind.
I'm not accepting it.
Okay, but I still have to do my job.
Okay.
Okay, and I still have to go over it and let you know that if this matter goes to trial, okay, and it goes to trial, and if the jury finds you guilty on both of these charges, one is a felony possession of methamphetamine, absolute or the maximum possible penalty, a $10,000 fine up to 3.5 years of incarceration. So 1.5 years of initial confinement, 2 years of extended supervision. The second is a possession of drug paraphernalia. Okay, if you're found guilty of that charge, maximum penalty up to 30 days of jail and up to a $500 fine. Okay, and those can be ordered to be whatever the court determines a sentence is. They can be ordered to be concurrent, served together, or consecutive, served one and then served the other. This is a possession of methamphetamine felony case. I'm not saying this will happen, but because it is a felony, there is a potential that it could happen, that if you are found guilty at a trial for a felony count, the court at that date and time right after the trial could revoke your bond and have you go have to sit in jail until a sentencing. Okay. And so that would be an immediate, and again, I'm not saying that is going to happen. That is a possibility that it could happen. Okay. And so the offer here is a deferred judgment of conviction, which is a document that you enter with the state that says, as long as you abide by this condition, you don't commit any new crimes that or conduct that rises to probable cause of a crime. You do an AODA assessment, you do other certain things and you get that documentation to the state that after a period of 12 months, the possession of methamphetamine felony is amended to a possession of amphetamine misdemeanor for costs only, no chance of jail time, okay? With the recommendation to the court. Court can always decide, no, if you complete it, then the court can't do anything. It is simply just cost because that is what the agreement is. So do you understand the offer that's been presented to you?
Yes, I understand it.
And do you wish to reject that offer?
Yes.
Okay, and so this matter will be going to trial. And so be prepared for that. The only way it will not go to trial is if you plead guilty to both of those accounts as they are charged, or if the state dismisses those, okay?
Okay,
Otherwise, we are currently set to go to trial on August 4th at 8:30 a.m. Any other?
This is where the hearing takes a significant legal turn. Rather than denying the defense request because of a procedural mistake, Judge Melissa R. Mogen considers whether allowing additional briefing would better protect the fairness of the upcoming trial. In criminal cases, procedural rules matter, but courts also strive to avoid unnecessary appeals if an issue can be resolved before a jury hears the evidence. By allowing the parties to submit additional written arguments, the judge focuses on reaching a legally sound decision instead of relying solely on a filing technicality. Do you think the judge made the right decision by allowing the defense another opportunity to present its argument? The answer could influence what evidence the jury ultimately hears.
Mr. Matrius?